This father, accused of a heinous crime, allegedly killing his own daughter, sits in court, even smiling at times, talking to his lawyers. This video per WTOL. Darnell Jones is not only just accused of killing his daughter, he's also accused of sexually assaulting and mutilating the body of 13-year-old Kei'Mani Latigue. This is the same man who also allegedly pulled a gun on police in Ohio when he was on the run.
What's your name? Kill me.
We're learning more about the clues police have that they say prove that Darnell Jones killed his daughter, and we'll show you Jones's reaction in court as the judge talked to him about the possibility of the death penalty. We're on the case presented by Law&Crime. I'm Chris Stewart. The story we're talking about today, the details are chilling. But it is a story that is a step closer to justice in the case of a girl who was found dead inside of a vacant home in Toledo, Ohio. This is Darnell Jones. He also goes by Darnell Ogletree. He's currently facing more than a dozen charges. He's facing 4 counts of aggravated murder, 2 counts of rape, 3 counts of kidnapping, aggravated battery, 2 counts of endangering children, and 2 counts of tampering with evidence, not to mention a count of gross abuse of a corpse. Jones appeared in court to enter a plea. This is video per WTOL of the judge addressing Jones.
As I said, I have a lot to go over. I want to make sure you understand. Okay? What's your name?
Jones is currently being held without bond. Jones said he's currently on medication for anxiety and for pain related to what he called the accident. What he may be referring to as the accident is this.
Come here, man. Don't do it. What's your name? Kill me.
Dude, show me your hands right now.
Me, bro.
Pull your hand out of your... I swear to God, pull your...
This was on March 25th as police searched for Jones in connection to his daughter's murder in Toledo, Ohio. Police approached him in Columbus, Ohio, and he allegedly tried to pull a gun. YouTube rules don't let us show you the moment that officers fire and hit Jones, but you might have heard him tell officers, quote, "Just kill me."
Shots fired! Shots fired! Dennis in a second! Get medic,
Don't move!
Don't move!
Alright, suspect down. All you guys are okay.
Don't move. He's got 33 right there.
33 in his hands!
No, it's a walkie-talkie, but there's 33s right here. Don't you move or you're going to get shot, okay? All right? Got it. Yep. That's him. Somebody get
on the main air. Get us a medic.
I'm working on it.
Jones faced a charge of felonious assault on a police officer, but that case was dropped so he could return to Toledo to face the more serious charges of allegedly killing his daughter. Jones's daughter, Kei'Mani Latigue, went missing on March 18th. On March 24th, she was found dead inside a vacant home in Toledo, Ohio. The Lucas County coroner said Kei'Mani's cause of death was related to multiple incision wounds to her neck. Something sharp like a knife was used to kill her. A grand jury indictment of Jones showed he allegedly did far more to the young girl. The indictment specifically says that Jones allegedly committed the offense with sexual motivation and says he is a sexually violent predator. The grand jury also says that Jones allegedly tortured or cruelly abused his daughter and that Jones allegedly treated a human corpse in a way that would outrage reasonable community sensibilities. Newly released warrants obtained by WTOL show that when Kei'Mani's grandma, who was the one who had custody of the girl, came home one night, Kei'Mani was gone, but her underwear and pajamas were in the kitchen, a place she told police the girl never changed in. Police then interviewed Jones and his cousin, Kalop Jones Dixon, and felt that they were both not being truthful. The warrant says that police searched the house where Jones lived with his girlfriend and took several pieces of evidence. Jones's girlfriend told officers that Jones wanted a home security system turned off the morning Kei'Mani went missing. The warrant also states that police learned of an alleged phone call between Jones and his mom. She told police she hadn't spoken to her son. Police searched the home of Jones's cousin and they left with a pistol, ammunition, multiple phones, tablets, a sweatsuit, a hatchet, a knife, and a DNA swab that was taken from a red spot in the home. As of right now, Darnell Jones is the only person who is charged in the death of 13-year-old Kei'Mani Latigue. I want to take a moment to talk about some of the content that you see here on the case and on Law&Crime, and it really shows just how rampant crime is right now. And that's especially true when we talk about cybercrime. It's becoming more widespread and more dangerous, and it's targeting businesses in ways like never before. Did you know that in 2024, 1 in 5 businesses fell victim to ransomware, and half of those were small businesses? But don't worry, Apollo Networks is here to protect your business and help you fight against these business-ending threats. They use the latest cybersecurity technologies to monitor your systems 24/7, stopping threats before you even know they're there, preventing downtime and safeguarding your data. Beyond just protection, they optimize your daily operations by managing your backups, providing 24/7 tech support, and being your trusted partner for all your IT needs. Their mission is simple: deliver elite level security while helping your business run faster, more efficiently, and with peace of mind. No business is too big or too small. Whether you have 1 computer or 1,000 computers, they can come up with custom solutions for any industry. So head over to apollonetworks.com/onthecase. You can also scan this QR code on your screen for a free network health assessment and 50% off your first month. According to WTOL, police think that Jones killed his daughter inside the vacant home on Miami Street after dragging her into it. In court, Jones, though, for as serious as those charges are, as disturbing as those allegations are, he looked laid back. Sometimes he did wince in pain, but in other moments he even smiled when talking to his court-appointed defense attorney. The judge read Jones all 15 charges against him, and then his attorney entered his plea.
And you'll see in count 9, that's the 3rd kidnapping charge, alleging that you did by force, threat, or deception remove Kei'Mani Latigue from the place where she was found or restrained her liberty for the purpose of terrorizing or inflicting serious physical harm on Kei'Mani Latigue or another violation of the Vice Code. Also kidnapping, a felony of the 1st degree with the same 2 specifications as the other 2 kidnapping charges. When we get down to count 10, it's now aggravated burglary, a felony of the 1st degree. Now that alleges that you did, by force, stealth, or deception, trespass in an occupied structure or in a separately secured or separately occupied portion of an occupied structure when Kei'Mani Latigue, a person other than the accomplice, was present with the purpose to commit in the structure or in a separately secured or separately occupied portion of the structure any criminal offense to wit, rape, that you inflicted or attempted or threatened to inflict physical harm on Kei'Mani Latigue, constituting the crime of aggravated burglary, felony of the 1st degree. Counts 11 and count 12 are both endangering children. They're a little bit different, so I'll describe each one to you. The first count, that is count 11 of endangering children, alleges that you did abuse Kei'Mani Latigue, a child under 18 years of age with his birthday provided, constituting endangering children, with the furthermore clause that the violation resulted in serious physical harm to Kei'Mani Latigue. And the other endangering children charge, felony of the 2nd degree, count 12 of the indictment, alleges that you did torture or cruelly abuse Kei'Mani Latigue, a child under 18, constituting endangering children, and that the violation resulted in serious physical harm to her. Okay, count 13, gross abuse of a corpse, felony of the 5th degree. That count, Mr. Jones, alleges that you did, except as authorized by law, treat a human corpse in a way that would outrage reasonable community sensibilities, constituting gross abuse of a corpse, felony of the 5th degree. Finally, with counts 14 and 15, each of them is a count of tampering with evidence. Each of them is a felony of the 3rd degree. Each of them allege that you did, knowing that an official proceeding or investigation was in progress or was about to be or likely to be instituted, alter, destroy, conceal, or remove any record, document, or thing with purpose to impair its value or availability as evidence in such proceeding or investigation, in violation of the law, constituting tampering with evidence, a felony of the 3rd degree. As I said, counts 14 and 15 are essentially the same. Do you understand what I read you? Are you clear?
Let me see if I can be a little more precise. Okay. So, with respect to count 1, Judge, to the charge of aggravated murder on behalf of Mr. Jones, we offer a plea of not guilty.
This is a story, for obvious reasons, that has shaken the community of Toledo, Ohio. This is where the vacant home where Kei'Mani was found once stood. The home actually recently burned down in a fire that authorities are still investigating. Our cameras captured a large memorial that sits on the side of the road in honor of Latigue, with people wearing clothing with her name and face printed on it. This is a case that could put Darnell Jones on death row. We watched during the arraignment how Jones reacted when the judge told him that this was a capital murder case. More video here from WTOL. There are also major questions for the Family Services organization in Lucas County, Ohio, that did have interactions with Kei'Mani Latigue and her family. The head of the Lucas County Children's Services said they feel they were thorough in her case. They say that Kei'Mani was in custody of her grandmother, who admitted that at times she used physical discipline, but there was no evidence that meant Kei'Mani should be taken from that home. They also say that the teen told them that she felt safe in that home with her grandmother. A task force is being formed to review the organization and how they handle cases of children in Toledo. According to WTOL, more than 200 people have already applied to be part of the task force, and as many as 20 will eventually be picked. The station says no specific cases will be reviewed, but the task force was launched over questions about the handling of the case involving Kei'Mani Latigue. Ahead of the court appearance that Darnell Jones first made in Toledo, I spoke with former prosecutor and Deputy Attorney General for the state of Ohio, Mark Weaver, and this is what he said about the case. Joining us now is prosecutor and former Deputy Attorney General for the state of Ohio, Mark Weaver. Thank you, sir, for taking the time to be with us on what is such a difficult story. We have this 15-count indictment returned by a grand jury. What should we take away from what the grand jury put forward in this case against Darnell Jones?
This is Lucas County, Ohio, where Toledo is. We don't see a lot of death penalty cases coming out of Lucas County. This will be a death penalty case unless it gets reduced in some sort of plea agreement. So this will move forward as a death penalty case. I've worked on numerous of them, both death penalty cases, both as Deputy Attorney General and then as a prosecutor. Much more difficult case to bring. Every bit of due process you can imagine is built into it. All of the work of the prosecutor has to be exacting and painstaking to make sure everything is done correctly. So I imagine that the Lucas County prosecutor will put their very best people on this.
And when you look at a 15-count indictment, and it's horrific what this man is accused of doing to his own daughter, what is the difference between a grand jury putting forth an indictment and then where the process goes from here, where eventually, if Darnell Jones is convicted, the difference between that grand jury phase and then the trial jury phase?
Under the Ohio Constitution, every felony charge must be brought forward by a grand jury. As your viewers know, that's a group of citizens who meet in secret and look at the evidence to see if there's probable cause that a felony was committed. So the grand jury handed up this 15-count indictment with all of these felonies, any one of which could serve 10 or 15 or 20 years. Some of these will merge, meaning that he can't be sentenced on all 15 of them, but he can be convicted on all 15 of them. And it now moves to the trial process. So there will be pretrial motions. Almost certainly defense is going to raise some sort of competency issue. There's very little daylight for them to be able to move around in this case. So I would imagine we're going to see some form of incompetency issue. Maybe they have some quarrel with how he was arrested or if there was a search warrant. So there's likely to be a motion to suppress. So these pretrial motions that happen in the months ahead of a criminal trial, that's the phase we're moving into next.
You look at this case and the family was known to the local Child and Family Services organization in Lucas County, but there was no evidence from what we've heard so far that there was no evidence to remove this child from the house from previous instances. She had been in the care of her grandmother. In your experience, what do you take away from what we're reading about some of the potential red flags leading up to the death of Kei'Mani Latigue?
Well, there's the criminal case, and it appears this man, Darnell, two different names, last names, I'm not sure which is the right one, but it seems like Darnell is squarely at fault and culpable for this case. He's presumed innocent until he's proven otherwise, of course. But then there's a civil case, potentially, to see whether or not the county committed any negligence in supervising this child. I've worked with a lot of children's services agencies over the years, and here's the thing that most people don't know. they are overwhelmed with cases. They're overwhelmed with allegations and referrals, and they are not mind readers. So when they go out to a home to do a check on a child, they can't know that perhaps there's a father out there with deeply evil intentions who's going to show up one day and do the sort of crimes that this man has been charged with. And so it's a high standard to sue the county to say that they're somehow responsible, but we see it often in cases like this.
And you look and I just think of your time as a deputy attorney general, and you see some of the challenges in the state of Ohio. And we've heard, stories of child and family services organizations, how overwhelmed they are. And sometimes it seems we only hear about them in cases where people are like, why didn't you do more in that situation? But in these cases, I mean, typically, what is the bar? And I know your experience is more from the prosecutor's side, but what is the bar to remove a child from a home?
Well, and ironically, in Ohio, the prosecutor's office is the statutory counsel for the Children's Services Agency. So when they get sued, the prosecutor defends. It's not true in every case, but it is in Ohio. That's how it works. You have to be able to show that the people who were supposed to be monitoring this child, the people who work at the Children's Services Agency, had some reason to know that this was possible or even likely, and that they ignored that. It's a pretty high standard. It can't just be that they weren't careful and didn't check every box. It has to be something that would suggest that they were well outside what we expect from our children's service workers. And if that's true, then the county can be sued for money damages, and that case would be brought by the family of the dead child.
Going back to talking about the death penalty and the possibility of that being the fate of Darnell Jones, if he is indeed found guilty of what police are alleging, what does the process look like where someone commits murder? It's awful. But if they were to commit murder at the level of what we're reading in this grand jury indictment and what police are saying he did, how does it get to that bar where the state decides that this is a case where life in prison is not good enough if someone's found guilty?
So in most states, certainly in Ohio, we have murder charges, and then we have aggravated murder charges. So murder is your actions killed somebody, and aggravated murder is your actions killed somebody, and you acted with prior calculation design, and maybe it was a certain kind of somebody. Maybe it was a police officer, maybe it was a child under 13, or in this case, maybe you were committing another felony in addition to the murder, and that makes you death penalty eligible. These are aggravating circumstances to murder, which is why we call this form of murder aggravated murder, or also known as capital murder. Now, let's be clear. I will not be surprised, nor should your viewers be surprised, if there is a plea agreement that goes something like this. Prosecutor to defense counsel, if your guy will plead to ag murder without the death spec and accept life in prison, we will drop the death penalty charges. We'll go, and this will be done in a few months. I suspect that sort of conversation will happen. Who knows? The defendant has to agree to that. Maybe he thinks he can roll the dice and get past this. But if he would like to avoid being executed, that's one way to do it.
Why would the prosecutors, if they have, and it appears they have a lot of evidence, apparently he also admitted to police officers that he did this. That was according to WTOL and documents that they looked through. So it seems like if you're prosecutors, why would you want to make a deal if you already have a mountain of evidence and you feel pretty good about how strong your case is?
As a prosecutor, I always want to move forward and try cases. I do this on a part-time basis. In Ohio, you can be a part-time assistant prosecutor. So this is where I get my jury trial experience. So I enjoy prosecuting cases, but sometimes it's better to resolve it this way. Here's why. Number one, we have not had an execution in Ohio for more than 8 years. There's been a dispute over the form of execution, which is lethal injection, and the kind of chemicals available to make that lethal injection happen. So Ohio is not currently executing people. Number two, there is so much scrutiny on death penalty cases in the appellate process. It can go on for years and years and years. And the loved ones of the person who was murdered don't get the closure they would if there's a sentence that says, yep, you're going to prison for the rest of your life. You pled to it, so your appellate rights are very limited. If it's resolved that way, the victim's family will leave the courthouse knowing almost certainly that this life in prison sentence will stick. In a capital case, and I remember meeting with the families of the victims of a serial killer who I prosecuted in a death penalty case. I met with him right after the conviction and the sentence, and they asked me, "Is it sure? Are we sure that this is going to happen?" And as I always say, you can never be sure. In a death penalty cases, there are so many appellate rights and so much scrutiny brought on it. Any court, state or federal, can overturn that verdict and send it back down for another trial.
What does the timeline look like on this case? And how do we get to a point where the judge or jury would say that the death penalty is what we're going with for a sentence for Darnell Jones if he's found guilty?
So from the date of the indictment, a defendant has to be brought to trial within 270 days in order to guarantee his speedy trial rights. If the defendant is in jail awaiting trial, every 1 day counts as 3. So it's essentially 90 days to bring it. What almost always happens, I haven't seen this in this file yet, but what almost always happens, the defense waives that speedy trial right so they have time to look at the evidence. Or if they file motions, it tolls or pauses the speedy trial clock. So in theory, it's supposed to happen in 90 days. Almost never does it happen in 90 days because of those pausing events that I just told you about, either voluntarily pausing or filing a motion that causes them to pause. During this time, the defense counsel will be looking at all the evidence that the prosecutors and police have amassed, looking for some hole in the case. As I mentioned, probably filing a competency motion or filing a motion to suppress, trying to find some way to get their guy out of what appears to be a pretty strong case.
Yeah, and I think too that it's not the only case that he's facing, because when he was arrested, he allegedly pulled a gun on police and police had to shoot him. We had the body cam video of that. So he's facing felonious assault on a police officer in Franklin County, Ohio. How does it work where he has a lot of layers to his legal case in Lucas County, but then you also have a very serious case in Ohio as well, in Columbus, Ohio?
Yeah, Franklin County was where Columbus is. That case has been dismissed for now. It can be brought again. They dismissed it in Franklin County to allow for the extradition of this defendant back to Lucas County, where his real problems are. I wish I could tell you that people who commit felonious assault on police officers in Franklin County go to prison for long periods of time, but they typically don't. And so I'm sure that the Lucas County prosecutors were happy to have the case essentially dismissed in Franklin. It could be brought again, but his real problem is in Lucas County. I wouldn't expect that you'll see anything in Franklin County unless something goes sideways in Lucas. If for some reason there was a procedural defect and that case gets dismissed, then you would see Franklin County, hopefully, depending on that prosecutor's ethos, bringing a strong case for that felonious assault charge against the police officers in Columbus.
Yeah, because how long does you would think someone who would pull a gun on a police officer and in that situation that would be enough for someone to see prison time, but that typically doesn't happen there?
Well, there's a lot of it. First of all, there's a 6-year statute of limitations, so that case can be brought anytime in the next 6 years. But depending on the judge you get, and judges are elected in Ohio, and different judges have different perspectives. Some of them come from a defense lawyer background, and they're much less likely to give out a serious sentence. And so as a result, the best chance for this defendant to be in prison for the longest time is going to be this case in Lucas County, which will either be pushed to a death penalty trial, which is a significant, difficult undertaking, or as I suggested, will be pled down to a straight aggravated murder without the capital spec, meaning life in prison without any possibility of the death penalty.
I'm always fascinated for the people who try cases and the responsibility, and you know it as well as anybody, the responsibility you carry, even in a case where it seems like you have every piece of evidence in the world to convict this person who's incredibly dangerous based off his criminal record in the past and what he's accused of right now. What is it like to be in the prosecutor's office and being the person who is going to be trying this case if it gets to that point?
It's an exhausting process. As the prosecutor, you have the complete burden of proof. The defense counsel doesn't even have to prepare and show up with a case. They do, but they have no burden of proof. And so when we all sit down at trial and the jury takes their seats in the jury box and the judge looks over to the prosecutor and says, "Mr. Weaver, on behalf of the state of Ohio, you may begin." All of the burden is on us. Have we identified every possible witness and given it to the defense? Have we talked to each witness so we know what they're going to say? Do we have our questions ready? Have we marked every piece of evidence? Was it gotten properly? Was it shown to the defense counsel? Then we have the questioning process. The other side gets to cross-examine, and we come back and we get direct examination. Then we have the opening and closing statements, and we have maybe a rebuttal case, which comes after the defense case. At any point, if the defense counsel says something was done wrong and asks for a mistrial, the entire thing can stop and has to start over again, or in significant cases, sometimes can't even start again. So the prosecutor's got a tremendous burden on them. I will be in trial next week, for example, on a child rape case that I'm on the prosecution team for. And so I know this weekend I'll be spending a lot of time looking at that evidence, preparing my portion of the case, and getting ready for what is a very important case.
And you look at this story, and in hindsight, you look at Darnell Jones, and he had a record that included arson, carrying a gun when he wasn't supposed to. There was an assault case that he had in the past. Nothing related to sexual misconduct from what I was able to see, sexual assault, or something as serious as murder, as he's accused of in this case against his own daughter. He did not have custody of this girl. It seemed like Child and Family Services was at least aware of the family. And I just look at this, and it's what more could have been done. And just in your experience, what more could have been, what needs to change in the system so you don't have a situation like this? Or is someone like Darnell Jones, who just seems, from what he's accused of, over and over and over again, committing crimes, just someone in, I don't know if inevitable is the word, but it just seems that what more could have been done to stop him from what he's accused of doing?
I spent most of my career working in and around law enforcement, local law enforcement, county level, state. I was a spokesman at the Justice Department in Washington, D.C. early in my career. And so one thing I've seen looking at all these cases is that there is evil in this world, and there are people who are willing to commit that evil. There is nothing we can do to make that go away completely. We want to do the best we can with the tools we have, but we live in a free society. And so the ethos of the founding of America is that people get to be free of government intrusion and government surveillance to the greatest extent possible. So we don't know what lives in the hearts of people who are thinking about what they're going to do to somebody. What we want to do is, once somebody is identified as a violent person in another case, we need to give them longer sentences, because one thing we do know, that if they're behind bars, they can't prey on innocent people in the community. Longer sentences helps, stronger sentencing laws helps, and having a serious approach to law enforcement and supporting our police. These things are all important ways to keep us all safe.
All right, Mark Weaver, former Deputy Attorney General of the state of Ohio and prosecutor. We appreciate you coming on. I mean, this is such a sad story, a tragic story, and your perspective really helps us break it down. Thanks for being here.
Let's all pray for this family. I know I am. Thank you.
That will do it for this episode of On the Case, presented by Law&Crime. I'm Chris Stewart. We'll see you next time.